We shall now move on to discuss Article 344. Article 344 deals with Language Commission and Parliamentary Committees. Article 344 contemplates the constitution of a language commission at the expiration of 5 years from the date of commencement of the constitution. It further contemplates the constitution of a language commission at the expiration of 10 years from the date of commencement of the constitution. The purpose of constituting a language commission is to enable the progressive use of Hindi in official communications as the official language of the Union, to restrict the use of English in official communications, to promote the use of numerals, Indian form of numerals, and to discuss about the form of numerals to be used, to discuss about the language to be used in the authoritative text of bills, to discuss the language to be used in the high courts and supreme courts, and also to discuss other matters regarding the use of language in intergovernmental communications. Now, if we look at Article 344, as we said, it contemplates the constitution of a language commission, and accordingly, the first language commission was constituted under the chairmanship of Shri B.K. Dhar, popularly known as Dhar Commission. So, Dhar Commission was constituted under the Article 344, it submitted its report. So, as per the constitutional provision contained in Article 344, the report of the commission is to be considered by a parliamentary committee. So, this parliamentary committee is to be composed of 20 members from Lok Sabha to be elected by the House, 10 members from Rajya Sabha, again to be elected by the respective House. This committee is required to consider the report submitted by the Language Commission. So, once the V.K. Dhar Commission made its report, it was considered by the committee, parliamentary committee, and that report is further sent to the President for taking action. So, the President, after considering the report of the parliamentary committee, in 1960 issued a constitutional order, and that constitutional order directed the Union to make Hindi, or to provide for the training of Union officers in Hindi, especially those which are above class 3 and less than 45 years of age, to promote the spread of Hindi and also to make Hindi as the language, as the official language. This presidential order, or the constitutional order of 1960, also directed that Hindi, working knowledge of Hindi may be made as a qualification for Union services, especially in those areas where Hindi has been adopted as the official language. It further directed that Hindi may be made as working knowledge of Hindi may be made as a qualification in other areas also, after giving a sufficiently long notice. This direction was complied with, and the Union of Home Ministry of the Union issued directions in this regard for compliance, and Department of Post and Telegraphs and Railway Board issued directions, and they made working knowledge of Hindi as a necessary constituent after sufficiently long notice. This was challenged in Union of India versus Murasoli Maran, where the Supreme Court gave its decision in 1977. Earlier, when the matter went to the Madras High Court accepted the challenge, and then the appeal went to the Supreme Court. Supreme Court rejected. It was contended before the Supreme Court that the President does not have the power on two counts. Number one, the second language commission, which was required to be appointed at the expiration of 10 years from the date of the commencement of the constitution, has not been appointed, and it was only a transitional provision. So, the President has lost his power when that second national commission has not been appointed. Second, it was contemplated that India has enacted Official Languages Act of 1963, and therefore, this provision, this constitutional order is not in compliance with that, is not in conformity with that Official Languages Act, and hence being inconsistent needs to be struck down. However, the Supreme Court did not agree with these contentions and upheld the constitutional order. Now, if you look at the Official Languages Act of 1963, this act also contemplates that the parliamentary committee shall be constituted on the same lines as a committee is constituted under Article 344 for considering the reports and for spreading the use of Hindi. Accordingly, we find that first parliamentary committee was constituted in 1976, and since then parliamentary committees have been reconstituted from time to time, the latest one being reconstituted in 2014. Now moving ahead to the second chapter of part 17 of the Constitution, that is regional, which is titled as Regional Languages. If we look at Article 345, that talks about the official language of the state. Analysis of 345 says that the state may declare any one or more languages in use in the state or Hindi as their official language. So one thing is very clear from a bare reading of Article 345, that states are not compelled to declare Hindi as their official language. That's what we said, that India has not declared any language as a national language. So the compromise solution was, which was adopted in the Constitution, that Union has declared Hindi as the official language for the purposes of the Union, and states have been mandated that they can declare any language which is in use in that state, or one or more languages in use in that state, or Hindi as their official language, not that they have to declare Hindi as their official language. Secondly, if we look at Article 345 and the proviso attached thereto, that says that English shall continue to be used as the language for all those purposes for which it was being used before the commencement of the Constitution, till a law is enacted to that effect, and that law excludes the applicability or exclude English as the language to be used in official communications. Therefore, we find that in Daya Bhai versus Natwarlal, it was challenged in Madhya Pradesh High Court that once the Madhya Pradesh has passed a law and declared Hindi as their official language, English shall be discontinued for all official purposes. However, the Madhya Pradesh High Court rejected this contention on the ground that English can be discontinued only when the legislature specifically excludes the usage of English. And in the instant case, the legislature of Madhya Pradesh had not specifically excluded the usage of English. Second important thing, if we look at Article 345 again, as we said, that the legislature can make a law and declare any one or more languages in use in the state or Hindi as their official language. And accordingly we find in UP Hindi Sahitya Sammelan versus State of UP 2015, the Supreme Court was confronted with an issue. The issue was whether after the declaration of one language as the official language in the state of Bihar, Bihar declared Hindi as its official language. In 1989, it made an amendment to its existing law and declared Urdu as its second official language. It was contended before the Supreme Court that this option could be exercised only once, and once they have exercised the option, this option is not open. Secondly, it was contended before the Supreme Court that the option with the state is either they declare one or more languages in use as their official language, or they declare Hindi as their official language. And once they have chosen to use Hindi, the other option goes away. However, the Supreme Court did not agree with these contentions, and the Bihar amendment making Urdu as their second official language was retained. If we look at Article 210, that talks about the language to be used in the legislature. And the perusal of the provision shows that in legislature, the proceedings of the legislature shall be either in the official language of the state or in Hindi or in English. But the provision of Article 210 says, the proviso says, that after 15 years from the date of commencement of the Constitution, the word or English shall be deleted. That means after 15 years, the proceedings in the legislature of a state are required to be in the official language of the state or in Hindi. However, the state legislature has been given the mandate that it can make a law and authorize the continuance of English in the proceedings before the legislature. If we look at this provision and the provisos attached thereto, for certain states like Himachal Pradesh, like Mizoram, the period of 15 years is extended up to 25 years. For Arunachal, for Goa, the period is 40 years. That means after 40 years, English cannot be used unless in the proceedings before the legislature, unless the legislature has passed a law allowing the use of English in the legislature of Arunachal Pradesh. So therefore, we have seen that various states have declared various languages as their official languages, be it Hindi, Konkani or any other language, or Punjabi. So we have discussed in this part the official language of the states and also the role of language commission and parliamentary committees. In the next modules, we shall be discussing the special directives and the 8th schedule.